Good evening all. I am here to welcome you all for the study circle meeting on incorporation of companies being conducted by Miss Shubhalaxmi. I would like to hand over the stage to her for the further discussion. Let's have a great learning.
Good evening everyone. Let's start the session. What is a company? A company means company incorporated under the Companies Act or any previous company law like Companies Act 1956. A company is a legal entity. A company is created by law. A company has a common seal and it has perpetual succession. The types of companies. The companies are limited by shares, associated company, holding and subsidiary company, public company, private company, one-person company, unlimited company, company limited by guarantee. And it also has Section 8 companies. Now let's learn about formation of companies with charitable objects, that is Section 8 companies. Section 8 companies also has which has support to the mankind. It has home to charity and service is given to all. Non-profit making organization or charitable organization, which is Section 8 company. Charitable object, that is education, research, social, welfare, environment protection, charity, religious donations. Income usage. Net income from the business and donation shall be used only in the charitable objects. Restriction on the dividend. The company shall not pay the dividend, however, it can pay interest, debentures and deposit, etc. The application first to be filed in Form INC 12 and in Form INC 13, Memorandum of Association and Article Association to be filed. INC 14, declaration by CA, CS and CMA should be done. In INC 15, details of Board of Directors and subscribers to be mentioned. Either central government will give the written permission to the ROC to register the company, that is in the Form INC 16, that is license under Section 8 subsection 1. In the application, if the application is directly made to the ROC, then the ROC can give the direct approval, that is from the Form INC 17, that is license under Section 8 subsection 5. Section 8 company will be either public or private. Alteration of the object clause of Memorandum of Association by Section 8 company will require prior approval of central government. In any some of the such contraventions, the company is not working as per its object, provided wrong information during the formation. Some consequences are the penalty for company, that is minimum 10 lakhs to 1 crore and for officer 25,000 to 25 lakhs. For revoking of license, conversion of limited company to private limited company, winding up of surplus transfer, if the same NPO is there, the same winding up of surplus transfer to the similar company, that is NPO to NPO, we can transfer the surplus, and also amalgamation with the same company, and insolvency and bankruptcy bankruptcy fund also to be transferred to the NPO. Next, let's come to know about some of the forms of companies. The companies are broadly classified into categories. Subsection 1 to Section 3 provides that the lawful purpose by subscribing their name to memorandum and complying with the requirement of the Act. Public company may be formed by 7 or more persons. Private company may be formed by 2 or more persons. One-person company as private company may be formed by 1 person. Further, subsection 2 to Section 3 provides that company formed as specified above may be incorporated either as companies limited by shares, companies limited by guarantee and unlimited companies. One-person company. The Companies Act 2013 for the first time allowed the formation of company by just one person with limited liability called one-person company. Who can form one-person company? Only a natural person other than a minor who is Indian citizen and whether resident in India or otherwise shall be eligible to incorporate one-person company. Let me ask you all one question. One person company, any non-resident can form or be a part of member of one person company. Let me see. Only natural person other than a minor who is an Indian citizen or whether resident in India or otherwise shall be eligible to incorporate a one person company. So even a non-resident Indian can be a part of a member of OPC. Let's move on to Section 7 of Companies Act 2013. Section 7 of the Act provides the procedure to be followed for the incorporation of company. Here are the steps for incorporation. First, determine the nature of company, whether the company is private or public. Then, reservation of name by filing an application. Drafting and signing of MOA and AOA. Submission of AOA and MOA to the ROC. Consent of persons nominated as directors. Next, submission of statutory declaration of compliances. Pay fees, amount of stamp duty, then obtain certificate of incorporation, file declaration about address and register office. Let's see one by one. Filing of the documents and information with the registrar, that is subsection 1. The company shall be legally created, legally constituted with legal object. As per section 3, the company to incorporate and manage necessary members and board of directors. Here, the member of public limited company as per section 2 subsection 71, the members should be only 7 and maximum is there is no limit and any person can be a part of the public limited company. Then private limited company as per section 2 subsection 68, minimum number of members should be 2 and maximum number should be 200. Any person can be a part of private limited company. One person company, that is section 2 subsection 62, minimum 1% and he should be an individual. Directors of public limited company. As per section 149(1), minimum number of directors should be 3 and maximum number of directors should be 15 and he should be an individual. Directors of private limited company, section number 149(1), for private limited company there should be 2 directors and for OPC as per section 149(1), there is 1 minimum director and he is the individual. An application for registration of company shall be filed with the registrar within whose jurisdiction the registrar office of the company is proposed to be situated in, that is SPICE Plus. Simplified proforma for incorporating company electronically plus, that is the form INC 32, along with fee as provided under the company's registration office and fees rules 2014. Let's see the SPICE Plus form. Here, type of the company, LLP or class of company, category of company, subcategory of company, main division of industrial activity of the company, particulars. There are part A and part B. Structure of companies, description, then how much capital structure of the company, authorized capital, subscribed share capital, then address of the company, subscriber and directors details, particulars of authorized person which has first name, middle name, surname, date of birth, Aadhaar number, etc. It has directors details and also shareholders details. and it has particulars of payment of stamp duty, PAN and TAN information, and attachments which is all needed. Spice Plus. It is an integrated web form offering 10 services by 3 central government ministries and departments, that is Ministry of Corporate Affairs, Ministry of Labour and Department of Revenue in Ministry of Finance, thereby saving as many procedures, time and cost for starting the business in India. Let's move on towards Memorandum of Association, that is Section 4 of Companies Act 2013. As per Section 250, subsection 56, memorandum means the memorandum of association of the company as originally formed as or as altered time to time in pursuance of any previous company's law or Companies Act. Clauses of Memorandum of Association, namely name clause, object clause, registered office clause, capital clause, subscription clause, liability clause, nomination clause is only applicable for OPCs. Let's move on towards name clause. The person shall make application for the name in INC 1 or Spice 32 to ROC. The application can be accepted considering some following prohibitions. The name which should not be identical or resembling name, and defensive name is not allowed. Undesirable name is not allowed. Name showing any connection with central government, state government, statutory company, body corporate is not allowed. Name which is prohibited words as per Rule 8A not allowed. The application can be accepted or rejected. If rejected, resubmit after correction in 15 days of rejection. If accepted, then the name will be reserved as follows. Primary, it is for 20 days, then additional of 20 days for payment of ₹1000, then additional extra 20 days on payment of 2000. So total 60 days on payment of 3000. The application for incorporation shall be made within above period of reservation. If not, the name can be allotted to the other company after this period. Object clause. Object clause means a purpose for which the company runs its business. There are two objects, that is main object of the company, then supplementary object, ancillary or other, that is low cost profitable. Registered office clause. The registered office is a physically presence of company's geographical area. It determines domicile and nationality of company. It also decides jurisdiction of court for registration. The books of account shall be kept at RO and place of general meeting as per RO. All official communications, legal communications shall be posted at registered office of the company. The address of RO shall be mentioned on all the invoices and official communication and also prospectus, letterheads, etc. Registered office is physical existence of the company as per geography. The company shall set up registered office within 30 days of its incorporation and shall file INC 22 with ROC. If there is default in setting up of RO in 30 days, the ROC can remove the name of the company. Capital clause and subscription clause. Capital is a part of own funds in the form of equity or preference in the company. The alteration of the company will require general meeting ordinary resolution under section 61. The capital can be altered in the following cases: in case of increase of capital and decrease of capital, and whether in the conversion of capital, division of capital and consolidation of capital. The alteration of capital shall be authorized by articles of association. The subscription clause is a key part of company's fundamental document, that is Memorandum of Association, where the initial shareholders declare their intent to form the company and agree to take specific numbers of shares detailing the names, address and share counts forming proof of the initial capital. Liability clause. Liability of members shall be limited or unlimited. It is an amount members agree to contribute the companies either as share capital or guarantee. Capital in the form of shares can be contributed throughout the life of the company. Guarantees a promise to contribute of winding up of liability is more than assets. Nomination clause. In case of OPC, the name of the person who in the event of death of the subscriber shall become the member of the company. The OPC contains only one member who is individual. In case of death of the original member, the OPC will not function. In such case, the nominee will become the sole member of the OPC and OPC will function as it is. Articles of Association. The Articles of Association are in fact the bylaws of the company. According to the directors and other officers are required to perform the functions as regards the management of the company, its accounts and audit. Contents of Articles of Association. Here are some of the contents of Articles of Association. Adoption of preliminary contracts, number and values of shares, allotment of shares, calls on shares, transfer of shares, forfeiture, reissue, surrender of shares, alteration of share capital, share certificates, conversion of shares into stocks, meetings and procedures, voting rights, proxies and polls, appointment, remuneration, etc., directors, borrowing powers, dividend and reserves, accounts and audit, procedure of winding up, and the seal of the company. Some of the points will be discussed later. Forms of Memorandum of Association. The forms of Memorandum of Association are from Table A to Table E and Articles of Association Table F to Table J. Memorandum of Association of Company Limited by Shares is Table A. Memorandum of Association of Company Limited by Shares and not having share capital is Table B. Memorandum of Association Company Limited by Shares and having share capital is Table C. Memorandum of Association of Unlimited Company of having share capital is Table D. Memorandum of Association of Unlimited Company having share capital is Table E. And Articles of Association from Table F to Table J. Declaration by subscribers to the memorandum and persons named as the first directors. A declaration in form number INC 9 from each of the subscribers, the memorandum, and from persons named as the first directors, if any, in the articles, stating that all the documents filed with the registrar of the registration of the company contain information that correct and complete and true to the best of the knowledge and behalf. He is not convicted of any offence in connection with the promotion, formation and management of the company. He is not been found guilty or any fraud or any breach of duty to any company under the act of any previous company law during the first 5 years. Let's see Form INC 9. This is form number INC 9, where the declaration by subscribers and first director is done. The declaration in respect of total number of first subscribers, the number of non-individual, number of individual first subscribers, total number of directors. Authorized persons of non-individual first subscribers, director identification number, and here the declaration is to be given. PAN should be mentioned. Particulars of individual first subscribers other than subscriber cum director. Other directors information. Declaration of compliance by professional and director manager or secretary of the company. A declaration that all the requirements of this act and the rules made thereunder in respect of registration and matters are incidental thereto have been complied with shall be filed in form number INC 8 by an advocate, by chartered accountant, cost accountant or company secretary in practice who is engaged in the formation of the company, and a person named in articles, that is director, manager or secretary of the company. Here is INC 8. This is declaration given by an advocate or chartered accountant or cost accountant or company secretary. Name of the company, then this is the declaration. This is the certificate of incorporation. Issue of certificate of incorporation on registration. The registration on the basis of documents and information filed shall register all the documents and information in the register and issue a certificate of incorporation in the form of INC 11 to the effect that the proposed company is incorporated under this act. Certificate of incorporation shall mention permanent account number of the company where it is issued by the income tax department. Form number INC 11. This is certificate of incorporation. Where corporate identity number of the company is mentioned and permanent account number is mentioned. Mailing address of the company, the name of the company is mentioned. Government seal will be here. Next, this is all about corporate identification number. Corporate identification number is a 21 alphanumeric digit based on unique identification number, comprised data of sections, elements that reveals the basic aspects about the company. The first digit states the listing status, and next 5 numbers states the industry code, next 2 letters states the state code, next 4 digits states the incorporation year, next 3 digits states ownership type, and next 6 digits states the registration number of the company. On and from the date mentioned in the certificate of incorporation, the registrar shall allot to the company a corporate identity number which shall be distinct identity for the company and shall also be included in the certificate of incorporation. Section 6. Act to override Memorandum of Association and Articles of Association. The provision of Companies Act 2013 overrides Articles of Association and Memorandum of Association. AOA and MOA overrides agreements, resolution and contracts along with the Companies Act 2013. Any provision which is contravention to Companies Act 2013 in MOA and AOA, contracts, agreements, resolution will be void and unenforceable. Section 17. Copies of MOA and AOA. Every company shall send copies of AOA and MOA and every agreement and resolution as per section 117 to the members on his request. In case of default, company and every officer who is on default shall be liable to penalty of ₹1,000 for each day and for ₹1 lakh whichever is less. Furnishing of false or incorrect information or suppression of material fact at the time of incorporation, that is during the incorporation period. If any person furnishes any false or incorrect particulars of any information or suppresses any material information of which he is aware in any of the documents filed with the registrar in relation to the registration of the company, he shall be liable for the action for fraud under section 447, which is punishment for fraud. company already incorporated by furnishing any false or incorrect information or representation, or by suppressing any material fact, that is after post incorporation, where at any time after the incorporation of the company, it is provided that company has got incorporated by furnishing false or incorrect information or representing false representation, by suppressing any material fact or information in any of the documents or declaration filed or made for incorporation or incorporating such company, or by an fraudulent action, then the promoters, persons named at the first director of the company, and the persons making declaration under the section shall each be liable for action for fraud under section 447. Section 10A. This is commencement of business. Every company shall, after its incorporation, ensure that board of director should file a declaration that the subscriber have brought the amount committed in 180 days. Additionally, the company shall file the physical verification of its registered office with ROC. The above declaration by board of directors shall be filed in the form INC 20A with ROC. Additionally, the declaration of CA, CS, CMA and advocate will be required with above filing. The approval of sectorial authority will be required within when 180 days of incorporation, that is the approval of SEBI and RBI. In case of any contravention of section 10A, the company will be liable to rupees 50,000 and or for removal of the name of ROC. Then the officer who is in default will be liable for rupees 1,000 per day, maximum up to rupees 1 lakh. Let's see the form INC 20A. This is declaration of commencement of business, section 10A of Companies Act 2013. Here the company's information, that is corporate identity number, name of the company, registered office address, email ID, longitude and latitude, whether the company's activities are regulated by sectorial regulator, that is RBI and SEBI or IRDAI. If yes, then specify the name of regulator. If others, please specify. Letter number, registration number, approval issued under section 406, date of approval or registration, regulatory body in case may be, details of subscriber, payment for value of shares, that is name of shareholder, name of the bank, account number, date of receipt and amount received. Attachments, that is photograph, certificate of registration issued by RBI, then any other attachments. Here is the declaration and it is to be digitally signed by the director. Director identification number should be mentioned, and here for certificate of practicing professional, that is chartered accountant, cost accountant or company secretary to be attached and also to be digitally signed. This is form number 20A. Next, let's move on to section 20, that is service of document. ROC or third person can serve document on the company, that vice versa, way of physical delivery, registered or speed post, courier, email, fax or any other means of which evidence can be obtained. Section 21, that is authentication of documents, proceedings and contracts, where the genuineness of the document, proceedings, contracts made or by on behalf of the company, etc. It is to be verified. We have to see whether the key managerial person or an officer who is authorized by the board to do has signed such documents. Section 94, place of keeping books and register. The company shall maintain all its books and registers at RO of the company for inspection, and if company has more than 10% of shareholders at other city, then the books can be kept at such city or place by passing general meeting special resolution. Register shall be preserved for 8 years, that is the books of account shall be preserved for 8 years. The shareholders, members, debenture or security holders can inspect or extract without fees, but if they want copies, that is rupees 10 per page is there. Then for others and third person, inspection, extraction, or they can take copies of 50 rupees. Then inspection by central government, they can inspect or take copies of any time without any cost. Let's move on to annual general meeting. In case of first annual general meeting, it shall be held within 9 months from the end of first financial year. In case of subsequent AGM, within 6 months from the end of financial year, within 15 months from last AGM, at least one AGM in one calendar year. Other provisions of AGM. The time of conducting AGM shall be held within the business hours, that is 9 to 6. Then the day, that is AGM shall be held on business days. Place, that is AGM shall be held at a registered office or city of registered office. Conduct of annual general meeting. Conduct of annual general meeting by company and conduct of annual general meeting by tribunal. Conduct of annual general meeting by company within 6 months from end of financial year, within 15 months from last annual general meeting, at least one AGM in one calendar year. Then conduct of AGM by tribunal. Tribunal may order AGM in following circumstances. In case of company being default to conduct AGM, in case of impractical for company to hold AGM, there is a penalty. If any default is made in holding a meeting of company as per section 96, 97 and 98, complying with any directors of the tribunal, penalty for the company and every officer in default for one time default, that is fine up to 1 lakh. For continuing default, a further fine up to rupees 5,000 per day for the defaulting period. Section 100. Extraordinary general meeting. The company shall conduct EGM of 10% of paid up capital or 10% of voting power holders may make requisition at the register office in writing form. After such requisition, the board of directors shall conduct EGM within 45 days and proceed to give the notice in 25 days. If board of director fails to conduct meeting in 45 days, then the requisitionists shall conduct such EGM within 3 months. In case of meeting is conducted by requisitionists, then the company will refund the entire amount of expenses to them from board of directors in default. General meeting. Section 96, that is AGM, which is regular, mostly every year we can conduct the AGM. Section 100, extraordinary general meeting, which is on special occasion. Section 102 is a regular or ordinary business which has the explanatory statement. We can in this general meetings we can declare the dividend, we can accept the accounts, we can appoint the director, and also we can appoint the auditor. Details of such business to be declared in the given details of such business to be declared and given under the explanation, that is in section 102, which is called as explanatory statement. Quorum of general meeting. In case of public company, 5 members personally present. If members is less than or equal to 1000, 15 members personally present. If 10 is 1000 less than 5000 members, 30 members personally present if members is more than 5000. In case of private company, 2 members personally present. If articles provide for the larger quorum than that given in the above table, such larger quorum shall be the quorum. In case of absence of quorum, the meeting shall be adjourned to the same time, same place, same day next week, or today. The time, place and place as decided by the board of directors. Minimum 3 days notice shall be given for adjourned meeting to members of the company. Minutes and resolution. The minutes of the meeting and resolution shall be kept at the registered office of the company. Inspection at registered office. Minimum 2 hours inspection shall be allowed on working days at RO of the company. Inspection by demanding copies. Company shall furnish the copy of the minutes within 7 days of demand made for inspection. In case of default to provide for inspection, there is a penalty. Penalty shall be there if any inspection under section 1 is refused or not furnished with specified time for company, that is rupees 25,000 for every officer in default, rupees 5,000 for each for refusal or default. Order of inspection by tribunal. Tribunal may order immediate inspection in case of default by company. Section 105, proxies. Proxies, share capital inbuilt right, then guarantee of articles of association, that is that right. Conditions, powers of proxies are they can attend the meeting, vote on poll, act on behalf of the member, demand poll. Restrictions of the proxies are create vote by show of hands, cannot speak in the meeting or discussion, cannot be continued in quorum except other members. One proxy is maximum, that is 50 members, and maximum SE of 10%. File proxy in form MGT 11 in 48 hours before the meeting. Inspect last 24 hours, that is in 3 days notice should be given. Filings with ROC. Section 117, filing of resolution. Section 114 is copy of resolution. Section 102, as said earlier, explanatory bank statements. MGT 14 should be formed in 30 days with ROC. If AOA is amended, also file the AOA. If you fail to file the resolution, the officer would be liable to pay of 1 lakh to 5 lakh rupees, and the company would be liable to file 5 lakh to 25 lakh rupees. Section 121, that is filing of meetings. Every listed company report of each AGM, that is date, area and time, and confirmation of meeting held property, that is you should declare it in form MGT 15 within 30 days of the meeting. If if there is any failure to file the MGT 15, the company shall be liable to pay the amount of rupees 1 lakh to 5 lakh, and the officer is liable to pay the amount of 25,000 to 1 lakh rupees. Thank you.